Right. Look, we may as well kick this off. So, hi everyone, and welcome to our unfair contract terms webinar with Molonglo Legal. I'd firstly like to acknowledge the country on which we meet today. Today, I come to you from the land of the Kombumerri families of the Ugambe language region, and I invite you to think on whose land you are residing on from your location. Sovereignty was never ceded, and the lands have always been and always will be Aboriginal land. I pay my respects to elders past, present, and extend my welcome to any Aboriginal or Torres Strait Islanders people joining us today. So welcome to our webinar. My name is Jens. I'm the Director of Industry Member Relations at IGEA, the Interactive Games and Entertainment Association. We're the peak industry body for the video games industry in Australia. Today, we're going to run a webinar on unfair contract terms. So from November on, there have been some significant changes in the unfair contract terms regime in Australia, prohibiting businesses from proposing, using, or relying on unfair contract terms in standard form contracts. With the introduction of significant penalties, many larger businesses have already modified their standard terms. But what are you going to do if you're a small business? How is this going to affect you? So today we're going to discuss this further with James and Maryana from Molonglo Legal. Thank you very much for making yourself available. Before I hand over to you, you probably know this, but just in case you don't, there will be an opportunity to ask questions, and we would like you to do that via the Q&A function. So please utilize that. Pretty straightforward. I'll lay those questions back to Maryana and James. Speaking of, well, I guess over to you.
Thanks very much, Jens, and thank you very much to IGEA for supporting us in putting on the webinar today. It's really great to have this opportunity to share our thoughts with the industry and have this platform to discuss. I'll share my screen now, which will take us to a PowerPoint slides, and hopefully you'll no longer see my beautiful face, but now should be seeing some fantastic slides. As Jens forecast, please feel free to chip in and ask any questions. There is a Q&A function. Otherwise, we will have time at the end. We've allocated quite a bit of time at the end of the hour to discuss some questions. If you want to chip in on the audio, I assume that'll be an option too. Very happy to take questions however they come. So thank you again for the acknowledgement of country, Jens. I won't do my own, but safe to say that I'm coming to you today from Ngunnawal and Ngambri country here in Canberra. By way of introduction, beyond that, my name is James Fisher. Some of you already know I'm the principal lawyer at Molonglo Legal, which is a Canberra-based boutique law firm specialising in corporate and commercial issues and with a particular focus on the video games industry. As you may have guessed by our presence today, obviously a large part of our client base is comprised of small businesses, as well as small businesses in the gaming space, and we take a particular joy in guiding those business owners through the complex world of corporate law in which many people find themselves unceremoniously thrust when they commence a business venture for themselves, and also game developers who find themselves dealing with complex ideas which aren't necessarily part of their core skills and expertise. So hopefully today we're able to share some of those thoughts and insights with you. My colleague Maryana Yako is going to be helping me out today with the presentation. Maryana's a lawyer in our team working remotely in Melbourne. Conscious we're all around the country today, so hopefully there's no technological issues. Rest assured the session is being recorded for posterity. So for those who aren't attending today in person, welcome. Hopefully any material points aren't lost in the ether and they're all regathered. You're very welcome to contact us by email in future, and our contact details are going to be at the back of the session. So today, as forecast, we will be discussing the recently updated unfair contract terms regime under the Australian consumer law. This came into effect in November last year, the 9th of November to be precise, and it applies to new standard form consumer contracts and small business contracts made from that date, which was 9th of November 2023, and to existing standard form consumer contracts and small business contracts, which are renewed or varied after that date. So, in very brief summary, the effect of the new rules is that from that date, 9 November 23, proposing, entering into, applying or relying on unfair contract terms in standard form contracts is illegal, and changes to the maximum penalties have commenced. Other key changes that influence the way that this regime applies and interacts with small businesses and contracts include whether a contract, the definition of a standard form contract, so how you determine whether a contract is in fact a standard form contract, expanding the definition of a small business contract to apply to a much broader range of contracts and businesses. And as I said, probably the most publicised change, which some of you may have seen in the papers, is the increase to the maximum penalties regime. This gives the legislation substantially more power, big sting in the tail than was previously the case. On top of that, each unfair term is deemed to be a separate contravention of the legislation. That means that multiple breaches in a single contract are actually possible, and those penalties can stack up really very, very quickly. Additionally, courts are going to be able to make a broader range of orders in response to findings of unfair contract terms, including orders to prevent those terms being used in future by those businesses in small business or consumer contracts. Look, all of the above is great information to be aware of generally. We're going to explore each of those points in detail throughout the session, and we're hoping as well towards the end to be able to deliver a little more insight from the small business perspective and perhaps tweaking that towards the video game industry. A lot of the intelligence and publications that have come out so far on this topic focus really on the implications for large businesses issuing standard form contracts to consumers and small businesses. We're hoping to reverse that a little and consider these issues from the other perspective. So, as I said, towards the end of the session, we'll be asking ourselves what's really changed as a result of this legislation for small businesses and how the new regime can be put to good use in negotiating contracts. So, without further ado, on to the next slide, and I'll hand over to Maryana.
Hey, James. I'm just going to close my video for this, just in case of any screen freezing, so you can hear me clearly. Now, the next few slides we'll be discussing defining what a small business is, what a standard form contract is, as well as what an unfair contract term really means and how to distinguish those with the fair contract terms. And we'll give you also some examples to look out for when you are reading your own contract, keeping in mind that this is from a gaming industry perspective. So we'll start with the first slide. Now, in order for us to understand how these changes impact studios that may meet the small business definition, we need to understand how the ACL defines a small business. This will assist the small gaming studios in understanding what redress they might have in contracts they enter and which may contain unfair terms. Now, the definition of small business contract has been broadened in several ways. One of them is that the headcount threshold was raised from 20 persons to 100 persons. Previous upfront price thresholds were replaced with a turnover threshold, including businesses with an annual turnover of less than 10 million for the previous income year. And thresholds were amended such that satisfaction of not both but either threshold would be sufficient for a contract to be considered a small business contract. Of relevance also is the type of contract. A contract must be of supply of goods or services, or the sale or grant of an interest in the land where one of the parties is a small business. The regime also applies to consumer contracts, which are contracts for the supply of goods or services, or the sale or grant of an interest in the land where one of the parties is an individual and the purchase is for personal, domestic, or household consumption of use. This has broadened, however, and as our focus today is on gaming industry and the small studios who meet the small business definition, we won't be dwelling on consumer particularly. The upshot of this change is that the regime now applies to a much broader spectrum of small businesses and therefore captures a much broader range of contracts, including many businesses. It is also worth noting at this time that the unfair contract term regime applies to contracts which have an Australian nexus in some way. This means generally that at least one of the parties must be an Australian entity. This also means that the unfair contract term regime applies both to onshore and offshore activities and entities conducting business in Australia, whether those entities are incorporated in Australia or overseas, and regardless of the governing law of the contract. And particular risks can arise if end user license agreement terms are adopted from terms that were prepared for overseas markets. It is therefore prudent for multinational businesses operating in Australia to have their agreements reviewed from the perspective of the Australian consumer law compliance. There was also another court case that was recently unanimously confirmed last year by the High Court. It's in reference to an old regime called the Carpick versus Carnival PLC, where the court said that a corporation that does business in Australia should be required, if it uses standard terms in a consumer or small business contract, to meet Australian norms of fairness, irrespective of whether the standard terms are in a contract made in Australia or one made overseas. And we'll move to the next slide, where we explain what a standard form contract is. The unfair contract term only applies where the small business contract is considered to be a standard form contract. The Australian consumer law does not strictly define a standard form contract, but rather a contract is presumed to be standard form, and the onus is on the party that prepared or is relying on the contract to prove that it isn't. In deciding what a standard form contract is, a court must take into account the matters set out in Section 27, subsection 2 of the ACL Act. That is, whether one of the parties to the contract has all or most of the bargaining power in the transaction, has prepared the contract without or before any discussion between the parties about the transaction, could effectively only either accept or reject the terms of the contract as presented. And we generally see this in end-user license agreements, which accompany download software. And the next point is they were not given any real opportunity to negotiate the terms of the contract, or whether the terms of the contract taken into account any specific features of the party or the transaction. It is important to note that this is often a question of opportunity rather than practice. That is, a failure to bargain or negotiate doesn't always necessarily mean an absence of bargaining power or the absence of the opportunity to negotiate. In spite of all this, a contract may still be standard form despite a party being able to negotiate minor or insubstantial changes, a party being able to select terms from a predetermined range of terms of the contract, or where a subset of counterparties negotiate the terms of a contract that is issued to a broader group of counterparties. And the next slide will explain the main three elements which must be satisfied before the term is considered unfair under the Act. The first one being the term must cause a significant imbalance in the parties' rights and obligations arising under the contract. 2, the term is not reasonably necessary to protect the legitimate interest of the party who would be advantaged by the term. And 3, the term would cause detriment, whether financial or otherwise, to a party if it were to be applied or relied on. Now, we'll explain the first element in more detail. The concept of a significant imbalance in the parties' rights and obligations was discussed in the ACCC versus CLH Rating Proprietary Limited case, where the court held that a significant imbalance would exist where a term is so weighted in favour of the supplier as to tilt the parties' rights and obligations under the contract significantly in its favour, which may be the granting to the supplier of a beneficial option or discretional power, or by imposing on the counterparty a disadvantageous burden, risk, or duty. The concept of legitimate interest is a little more unclear, and the courts have been reluctant to nail down a clear definition of the context in terms of the unfair contract terms. In ACCC versus Smart Corp Proprietary Limited, the court decided that it was not appropriate to attempt to define legitimate interest beyond a particular set of facts, as it will depend on the nature of the particular business of the relevant supplier, the particular circumstances of the business, and the context of the contract as a whole. It is clear, though, that a legitimate interest may not be monetary and may not be confined to reimbursement of expenses directly occasioned by the customer's default. It may be intangible and unquantifiable. The legitimate interest of one particular entity could therefore be different to the legitimate interests of another party. The concept of detriment in the definition of an unfair contract terms regime seems more straightforward, and it means that there would be some adverse impact on the consumer if the term was relied upon, even if the term is never actually relied upon in a particular case. Another important point to note is that the court will also consider whether the term is transparent. This means it is legible, expressed in plain language, presented clearly, and is freely available to all involved parties. If the term hides in the fine print or legalistic, complex language is used, it is unlikely that the term will be considered transparent. The court will also read the relevant terms against the contract as a whole. For instance, are there other terms in the contract which offset the unfair term? All the above to say that unfairness in each case will be subjectively assessed with the parties in question and in context of the contract as a whole. And moving to the next slide, where we'll just provide you some common examples that you might see in contracts. And these are, you might expect to see some that relate to a particular imbalance in termination rights, where one party can terminate and the other party cannot. We see variation rights, an imbalance there, limitation of liability. These terms are often made mutual to avoid that unfairness, and it's commonplace for this to be waved through in contract negotiations pricely, because there might not be a strong commercial rationale for granting a right to one party where it's withheld from the other. Also, moving to misleading statements, who have long been a concern under the consumer law. Any terms which mislead you by stating, for example, that the unfair contract term regime does not apply could itself be considered an unfair term. The exclusion of statutory warranties could also be another example which comes up. The last one being restraints of trade. You might see in employment contracts, for example. As you probably know, these are already likely to be very difficult to enforce, and are assumed to be unenforceable by default. Where that restraint is unenforceable due to being unreasonable, there is likely to be a strong rationale that it could also be captured under the unfair contract term regime. I'm sure from the collective experience of the group, as well as James with his expertise, we come up with a lot more examples that are relevant to the gaming industry as well. So just be aware that a particular clause might be unfair in one context, but it might not be, but it might be unfair in another. And I'll hand it back to James now.
Thank you, Maryana. So a quick consideration then of the penalty regime. I don't propose to dwell particularly long on the remedies available at court for the pursuit of unfair contract terms, but I'll cover them briefly. So broadly, the unfair contract term regime is enforced by the ACCC. Generally, they can take action by the courts against a party that might be in breach of the legislation, usually at the request of an injured party. On successful application by the ACCC, courts have very broad powers to void, vary, refuse to enforce unfair contract terms. As you're aware, they can also impose penalties, and under some circumstances, they might be able to order compensation to the injured party. Importantly, finding that a particular term is unfair will void that term. What that means is that that specific term is, to the extent it can be, excised from the broader contract. The entire contract, however, is not invalidated unless the effect of voiding that unfair term would be that the contract as a whole becomes meaningless without its presence. As I said, the biggest change to the range of orders that courts can make is in the penalties regime. So for companies, the penalty has increased to the greater of $50 million. It was formerly $10 million. And that $10 million threshold remains a consistent penalty amount across the remainder of the Australian consumer law. But in this case, for unfair terms, the $50 million threshold has come in, which is a massive increase. And worth noting as well, it's the greater of 50 million or 3 times the value of the benefit to the company of using that unfair term, if that's able to be determined, or otherwise 30% of the corporation's turnover during the offence period. Now, the offence period is the time, any time, when an unfair term existed or was relied upon and that breach subsisted. That could be 2 weeks, it could be several years, it could be a very long period of time. So 30% of the corporation's turnover during that period could become very rapidly quite a large number. Formerly, this was only 10% of annual turnover, and it was limited to the 12 months prior to the breach. So that's a substantial increase in the stick available to the ACCC and the courts in enforcing this regime. For individuals, it's a $2.5 million penalty, which was previously $500. So again, that's another massive increase. It's a 5-fold increase for both. As I flagged earlier on, these penalties will only apply to new contracts and renewals or variations of existing contracts that were entered into on or after the 9th of November 2023. So anything prior to that date, which is not varied, won't be captured necessarily and will have to be dealt with under the old regime. Also, as I mentioned earlier, the penalties above are assessed per breach, not per contract. So breaches here can also be coupled with breaches of other sections of the Australian consumer law, including, for example, misleading and deceptive conduct, unconscionable conduct, those sorts of rules, each of which carry their own financial penalties, which can stack on top of unfair contract terms breaches. And altogether, that can amount to a very large incentive for businesses to make sure that they're not relying on unfair contract terms, revisit their standard form contracts and drafting practices. As I mentioned before, many large businesses have already been encouraged to do so through these types of presentations. So all of that brings us to the core of the discussion today. What do small businesses, and in particular small businesses in the gaming industry, need to do in response to this legislation if they haven't done it already? So first of all, it's critical to understand that the regime applies to you as well, both as a recipient of an unfair contract term and as a person seeking to rely on an unfair contract term. It's only necessary for one party to the contract to be a small business, but the regime does operate if both parties to the contract are small businesses as well. On that basis, changes that have come in should be a trigger for you as a business to reassess the terms on which you're doing business using any standard forms. You need to make sure that you understand the terms that you're offering and the terms that you receive that are based on standard forms, and where there are terms which could be unfair for all of the reasons that we've outlined previously, you need to make sure that you understand the legitimate commercial reasons for having those clauses in place or modify them so that they're no longer unfair. This is really a matter of common sense and a commercial approach if you're not engaging a lawyer to do this work for you. I understand that a lot of small businesses have budgetary restrictions when it comes to legal work, and to the extent that stuff can be done in-house or by the people who are running the business, that's always an advantage. The rule of thumb I would suggest is that if something feels unfair, it probably is, as a very broad and general approach. And you should generally take the approach that those sorts of contracts are the ones that you need to be worried about, and you should expect that your counterparties are at least exercising the same level of caution as you are. So when you're dealing with businesses who are offering you a standard form contract, you should feel some confidence, so I should say some confidence, that the UCT regime gives you a bit of power to negotiate. That said, it's not going to be a panacea for all of your contractual woes. You shouldn't assume, for example, that a large entity has reviewed and allowed for unfair contract terms, particularly offshore entities that might not have given Australian law any consideration. But equally, many larger Australian entities will have given consideration to this regime, may have reissued and refined their standard form contracts, and may not have any room to give on those terms. Provided they have a reasonable commercial rationale for those unfair terms, there's not going to be anything to answer for under this legislation. That said, as I say, a lot of larger businesses have been reasonably responsible about adopting this legislation, and particularly those businesses that do a lot of business with consumers have really taken the front foot and rolled out some changes. Many won't have, however. So it's unreasonable to expect as well, if you're not dealing with a large company or with a company that isn't particularly mature in terms of its legal function, that the person that you're dealing with as a counterparty fully understands their obligations under the UCT. Critically, though, that doesn't alleviate the company or you from any of your obligations under this legislation. Regardless of all of that, it's one thing to say that this legislation exists and there are potential breaches of the legislation that exist, but there is another factor to be taken into account, and that, of course, is the commercial rationale for making any amendments or considering your course of action. At that point, really, there's a commercial call to be made to assess the value of what I will shorthand as making a fuss about these terms. If you want to get a deal done quickly and the commercial risk is reasonably low on these clauses, it might be worth pressing on with unfair terms in place and not challenging those terms. But that said, if it's not the case, or if you feel there is potentially some room to make a fuss, you should feel very confident that at the very least raising the unfair contract terms regime should get you a seat at the table. Many organisations, as I've said, will have come up with really good commercial reasons for terms which might at first glance appear to be unfair, but many of them will have adopted those terms purely on the basis that it's the contract that their lawyer gave them 10 years ago and they've never changed the form. In that case, they should absolutely be revisiting. It's never going to hurt to ask the question about the commercial rationale behind a clause, and there's always the possibility that the answer will be articulate and sensible, but there is the equal possibility that the answer may be, oh, we haven't thought about that in a long time, maybe we can reconsider. It's important to realise as well that renewals and extensions can now be used as an opportunity to challenge and negotiate if you want to, particularly given there's been a revamp of the regime. That definitely acts as a trigger, and you shouldn't necessarily by default accept terms that you previously agreed to without giving some consideration to them. I would suggest that it's probably unlikely that anyone on this call or listening to the recording is going to make a formal complaint or commence proceedings with the ACCC or ASIC on the basis of the unfair contract terms regime. And I'd say it's even more remote that that enforcement regime would actually be successful. And look, in part, that's due to my own personal bias against litigation and conflict coming through. I tend to see it as a very costly exercise that saps the energy and will to live of all involved. But that said, the threat of enforcement action and the very high penalties regime, and they are very high in this case, if it's used judiciously in contract negotiation, can be extremely effective and can negate the need to take formal proceedings in any way. That's not to say that there isn't a case for legislation in some litigation, I should say, in some circumstances, but to my view, particularly when small businesses are involved, the costs can often outweigh the benefits, and it's definitely worth seeking legal advice should you ever need to do so in that circumstance. But look, the great value of the unfair contract terms is really acting as an equaliser in encouraging larger businesses to actively engage in negotiations, genuine negotiations with smaller businesses, and forcing all parties really to consider what a genuine negotiation looks like. That's not to say that those negotiations will necessarily prove successful, but it's certainly a trigger to really consider what those imbalances are and what the commercial interest behind imbalanced clauses might be. As I said, while there are always exceptions, it's rarely the case that a particularly imbalanced clause has been drafted with a very specific consideration of the circumstances of the parties involved in a contract. Much more likely to be parachuted in from a template that the business has always used. And absolutely, the unfair contract terms should be a powerful trigger for all businesses to reconsidering how those clauses operate. So that brings us to the end, precisely on the half hour of the sort of formal end element of the presentation. There's no questions in the Q&A box, but if anyone's got anything they'd like to discuss or any issues that they want to bring up, very happy to discuss now, or otherwise you're more than welcome to shoot us some questions by email or by phone.
Yeah, thank you very much, James, and thank you very much, Maryana. Well done, finishing right on the half hour. How very loyally of you. All right, it's a great opportunity for you to ask questions and maybe dive a bit deeper into what these changes mean for you. All right, let's have a look. Thank you for covering the basics. Contracts have always felt like a big unknown to me. This has been very useful. Thank you, Timo. Thank you very much for the feedback. We'll take that comment on board. But yeah, if anyone has any questions, this is your opportunity to ask away.
We won't leave everyone hanging. If you would rather get in touch with us by email, there's our contact details as well. Please feel free to reach out if you have any questions at a later time. certainly happy to assist with contract law more broadly. We don't need to restrict ourselves to unfair contract terms, but certainly happy to discuss any issues as they come up.
Yeah, absolutely. I mean, have you seen much of this happening in the games industry? Have you been approached by many clients about this?
It's very early days in terms of, we're not likely to see ASIC or the ACCC coming out and hitting people with $50 million fines straight off the bat. It's a very new regime, and there's generally a grace period with these sorts of things where the regulator takes a fairly permissive attitude to this sort of regime, particularly where the penalties have ramped up so quickly. But that said, there was a long lead-in time to this legislation and a lot of noise being made for big businesses to get ahead of the change. So I wouldn't be surprised if there is some action at the very least in the next year or two. As I say, I tend to think that this regime is not likely to be a trigger necessarily for enforcement action. It's more something that should be used as part of the arsenal for negotiating contracts. A great example of something in the last 12 months that is very gaming specific, and I imagine many people on the call were aware of it at the time, was the Unity fiasco around, what was it, September last year? I think it was just before GCAP. Unity unilaterally changed their standard terms and conditions and forced additional fees, or purported to force additional fees onto developers at all different tiers, and it was per instance of the game sold and that sort of thing. Huge changes, sweeping changes to their general terms and conditions. And look, I'm not suggesting necessarily that would have been caught by the unfair contract terms regime, or even that a small developer would have the power and the capacity to challenge a huge American company using an Australian regime. Look how well Anthony Albanese has gone with Elon Musk in the last 24 hours. That's going to be a challenge for anyone. But that's a great example of unfair contract terms. It was a unilateral change, and in that instance, the fantastic power of social media and the games industry generally getting its back up about these changes being forced down from the top resulted in Unity, to a degree at least, backing down. And there was certainly grandfathering arrangements for previous iterations of the program, and new versions were what was the changes were intended to apply to. So I'd suggest that being aware of unfairness as a concept and something that can be used with quite a powerful effect is really important, and not just accepting what's given to you on face value. Whether the law is the right avenue to push back and force those changes in is another question. I think Unity is a great example of social media being very powerful in that sense. And but I'm not aware of IGA's role in any of that, but potentially for advocacy organisations as well.
Yeah, right. And at least they have a legal framework to fall back on. And I think the Unity example is a good one in terms of what can potentially be covered. I mean, I'm wondering sort of what's the context to the creation of this law? Has there been a whole history of unfair terms within corporate Australia? Has there been some precedents where it's like, okay, this is enough. We're just like, the buck stops here. We're going to introduce this new regime. Is there some sort of wider context to this?
It's a really good question, and the short answer is, but don't know. But to give you a bit of background, look, there has been an unfair contract terms regime in Australia for a very long time. It's part of the Australian Consumer Law, which sits at the back of the Australian Consumer and Competition Commission Act, so the ACCC Act, that gives them essentially the information about what they can and can't enforce. That's also where, for example, statutory warranty provisions sit for every consumer contract that we ever enter into, and any good we ever buy from any shop ever has those statutory warranties. And I'd say that awareness of that regime generally is pretty poor Australia-wide. But the reality is that Australia does have some very strong, on an international level, consumer protections and small business protections as well. The huge advantage of this is that, and look, really, the old regime wasn't really enforced much. There was some case law, but as we've seen, the penalties were relatively low, and the thresholds for, you know, what was a small business contract were much narrower. So this was really intended to broaden this regime and really give it teeth. And look, whether it has that effect, I suppose we'll find out. It's only 6 months old at this stage, or less than 6 months. We'll find out in the coming years. But really, the value of it potentially is in as a deterrent, I think, and a trigger to force people to reevaluate standard form contracts.
Yeah,
certainly,
very
I've seen
interesting.
that, you know, the big banks, for example, who obviously rely on huge numbers of standard form contracts every day, have gone through massive exercises with law firms much more substantial than my own, going through and reviewing those terms. And, you know, we've seen quite a number of very large clients really taking this seriously, even from an international perspective, because those penalties are so severe.
Yeah, I mean, God, $50 million is certainly nothing to
It's a lot of
sneer at.
money.
And, you know, you
And-
mentioned the strong
and-
Australian consumer laws, which is certainly something that Steam, for example, felt. You know, if I remember correctly, they've been fined a couple of $1 million.
Yeah, absolutely. And it is the greater of the 50 million and what is it, 30% of turnover for the breach period, which could be a much greater number, you know, particularly for many of the much bigger companies. You know, so the cap for those breaches is very, very high. And that's, you know, a really significant disincentive.
Yeah, all right. Well, just looking at the Q&A, there don't seem to be any further questions. Look, let's give this. Oh, I'm gonna give you one opportunity to ask one. So, you know, let's give it another minute or so. But otherwise, you know, I think we can wrap this up. Quick webinar is a good webinar, unless there is a question. So don't want to.
Speak now or forever hold your peace.
That's exactly right.
Look, thank you very much for having us, everyone, and taking the time to be here, and for anyone listening on the recording.
Look, thank you very much for
very
making yourself available. It's really appreciated. And, you know, as James already pointed out already, if you have any questions that go above and beyond the unfair contract terms, you certainly able, he and Maryana, they're certainly happy to make themselves available for that. It's always good to have a good lawyer on your side when you are in games, in particular when you run your own business. Expert advice will certainly save you a whole lot of trouble later down the road. So feel free to also reach out to James and Maryana for any other issues that you may have. But look, again, thank you so much for taking the time. Really appreciate it. And, you know, I guess have a good Anzac Day, everybody. Have a good long weekend, which I guess applies to 95% of every Australian, I would hope. And yeah, enjoy. Thanks for dialing in. Take care. See you later.
Thanks very much, all.